So Kabito is the current managing partner of Legal Mark Advocates, an Anderson Global member firm based in Kampala, Uganda. He is an advocate of the High Court of Uganda with over 20 years experience in insolvency, corporate and debt restructuring practice, banking and finance, finance leasing, commercial and civil law, law practice, and litigation. Kabito is a holder of a Bachelor of Laws degree from Makerere University, Kampala, and a diploma in legal practice from Law Development Center. He's also an INSOL fellow, as I earlier mentioned, having completed the Global Insolvency Practice course offered by INSOL International, a global association of insolvency, bankruptcy, and business turnaround specialists. Kabito is Uganda's leading and most recognizable insolvency practitioner, often representing secured lenders in matters of secured lender enforcement. He has served in various capacities, including liquidator, receiver manager, or consulting counsel for entities in copyright, intellectual property, information technology, agriculture, education, manufacturing, etc. He was part of a team of consultants retained by the Uganda Law Reform Commission to reform the insolvency laws in Uganda. That process led to the enactment of the Insolvency Act 2011 in Uganda. Kabito was also retained as official receivers consultant in the implementation of the Insolvency Act 2011 in Uganda. The Uganda Law Reform Commission also retained him as part of a team of consultants to study proposed reforms that led to the enactment of the present Companies Act in Uganda, the Partnership Act, and the Mortgage Act of Uganda. Kabito served as assistant counsel for the government of Uganda's second integrated financial management systems project, during which he advised on the legal framework that led to the establishment of the nation's Information Technology Association of Uganda. As a commercial litigator, Kabito is most known for representing banking and finance clients in matters of lender enforcement rights. However, he's also known for representing clients in major energy and infrastructure disputes. Because of his vast experience, Kabito is regularly called upon to facilitate training on insolvency and business rescue to various stakeholders, including judicial officers, postgraduate bar course students, etc. Kabito is currently the convener of Insolvency Cluster of the Uganda Law Society. Ladies and gentlemen, please make welcome Kabito Karamagi. Kabito, you have the floor. I think I'll help you share your
Thank you very much, Kobe. Thank you for the kind introductions. And thank you, Okori and team, the National Bar Association of Nigeria, for inviting me to share my knowledge with you. I feel terribly honored and quite boosted in confidence that you can ask me to come back after I visited you last year. I take this as a vote of confidence, and also it just tells me how much, even though we're many miles apart, we are really common in the challenges we have, in the experiences we share, and in the aspirations that we have as an African people. So thank you, Kobe. Thank you, Okori. Thank you, Nigeria Bar Association, for this kind invitation. Good evening, ladies and gentlemen, Ogas and Oga Madams, in all your respective capacities. I understand I'm speaking to all Nigerians from across Nigerian lawyers and practitioners, insolvency practitioners from across the nation. And I feel, like in those old days when there'll be a takeover, the first announcement was on radio. So, you just hear, this is a coup, we've taken over government. So I kind of feel that empowered, if at all I can ever get close to that, that I can speak to the many of you in your jurisdictions where you are. The topic that I have to speak today is about a multi-creditor enforcement rights, subject I've spoken about quite a lot. What I'm asked to speak about today is what are the guiding principles for creditor enforcement rights and in workout situations. This topic is quite pertinent because it speaks to a culture that I hope we can all adopt at some point as first of all as practitioners, as lawyers, as advisors. We are part of an ecosystem, enforcement ecosystem, that we must find a way to make work. Some of these processes may appear alien, but we can domesticate them. When I speak about workouts, workouts essentially are what you'd call the consensual or negotiated settlements between a debtor and his creditors. While this topic seems to restrict us to that, I hope we have time to talk about how we can go around to negotiate something of this nature, and how we can handle these rights, or how we can apply these principles even within a formal insolvency setting. Now, these principles, insol principles that I'm going to talk about, are born out of something called the London approach. The London approach was advocated by the Central Bank of England to kind of push the commercial banks at the time. I'm talking about the 1970s, to think differently about their enforcement of creditor rights against distressed companies. So the practice at the time was to enforce in a manner that led to liquidation. It didn't explore a business rescue. It was selfish in nature because it was about grab what you can and go. So the central bank thought that if the commercial banks coordinated their enforcement processes and explored ways of assisting a distressed entity out of its financial difficulty, there would be more value. So that encouragement was not really regulatory in nature, but it was, for lack of a better word, say a soft regulation. You know, when the regulator is winking at you and saying, do it. Even though it's not really quite the law, you are really obliged to do it. It's the regulator. That's the way the things work, isn't it? So that's how then this approach, you know, is introduced in the world in the 1970s. But also not far from that point, again in the 70s, somewhere in the 80s, we witnessed a wave of reform around the world, a reform of insolvency laws. The United Kingdom itself started its reforms probably around 1978, thereabout, with the institution of the Koch Commission, Koch Committee, that then led to the 1982, or do I have my dates right? I hope not, 82 report, and then leading to the 86 law and so on. So, but the work seems to start around in the 1970s. Pretty much the United States also does that in the 1978, and that's the first amendment you see to that insolvency law from somewhere, I don't know, 1910 or thereabout. And there's something in common that is being introduced by these reforms. It's about business rescue. So clearly in England, the legal reforms are following an approach that was introduced by the introduced by the Central Bank of London in the way distressed assets need to be managed. Now, around 1982, you also see the formation of this organization now called INSOL International. INSOL International is today the world's biggest body of bankruptcy professionals and business rescue advisors from around the world. But starting in 1982, of course, it was a small entity, and it was concerned more about how to share knowledge and promote the rescue of enterprises around the world, pretty much focusing maybe in Europe at the time. So, and when they sat, in time, by 2000, they had come and studied enough studies around how, what they thought would be a good approach to multi-creditor enforcements. And so they came about around to these principles that we're going to see. So the first principle is yes, or rather, maybe before we see the principles, let's talk about the rationale. Why was it necessary? They've been vindicated over time because the general experience, as it is now, is that rescue is better for creditors than an insolvency proceeding. You see, in an insolvency proceeding, generally, or a bankruptcy, the way we understood it, probably many of us, or maybe less of us, the way we understood it in school was that it was a liquidation or it was a death of an entity, liquidation that leads to the end, the lifespan of that entity, the business itself, liquidated. So what happens is that jobs are lost, the investment is lost, the economy loses, the key taxpayer is gone, and so on. So there was need to look at rescue in a way that benefits the general body of creditors. And it's found that when there's a rescue, creditors get more because the entity survives to pay its debts. Unlike a liquidation where when it dies, the creditors and the majority of them normally take the loss. Two, that where there is a workout of some sort, a better creditor enforcement workout of the banks, is that the reason why you have that you have a successful rescue is because you have a successful coordinated workout situation. The reason you do that is that because then the banks are not selfish, or the secured lenders are not selfish. They're working in tandem to aid the growth of this entity rather than working in isolation to get what they can and leave the debtor in whatever situation he has. So there we are. We have then viable businesses able to survive because it doesn't work in all cases. Viable businesses survive, and those that can't work, can't survive, are allowed to exit. So we have preservation of value, you have jobs that are saved, you have the investment that is saved. And in certain cases, I'm sure, as you all know, we come from the same continent and we have similar problems. The key entity that is sustaining economically in a particular region is, a player in such a manner that it's holding that community together. So children are able to go to school. You may think that all you're doing is giving jobs, but in all reality is that children are able to go to school. Farmers are able to sell their produce and things like that. So when this entity exits, this one entity exits, the entire economic livelihood of that area would sink. And then obviously when you have consensual approach to creditor enforcement rights. You see less litigation. You don't have to burden court with the unnecessary disputes. And a lot of value is then, and time is focused on how to grow this entity. These processes also facilitate what we call a preventive restructuring process. That's, in other words, you don't have to be insolvent. As long as you're able to see difficulty on the horizons, these kinds of approach, this kind of processes allow you to initiate a discussion with your lenders collectively, or those that are affected, enter into an arrangement with them and avoid the dark skies that are coming. So what are these principles? And so principle number one, I'll read it. Where a debtor is found to be in financial difficulties, all relevant creditors should be prepared to cooperate with each other to give sufficient time to the debtor for information about the data to be obtained and evaluated, and for proposals for resolving the debtor's financial difficulties to be formulated and assessed, unless such a course is inappropriate in a particular case. This principle I find very important because it defines what sort of creditors. Can you have all creditors in one room? Can you handle them and see how to ham out a workout? And the answer seems here to be that no, you don't have to have all of them. Deal with the relevant creditors. How do you identify these creditors? It is about their relevance and power on the negotiating table. So look at classes. The secured lenders, of course, those are secured by law. Their rights are secured by law. You want to talk to them. Theirs can't be far away from the negotiating table. But also, a secured lender may not be that exposed, so he's not that keen. So perhaps that one is not that interested. But then there might also be a key supply. His rights are not secured, but you need his supply. That's a relevant creditor. So it's about the power that a creditor brings to the table. That's the one you have to talk to. That's the one you have to engage, and that all of them are able to talk and give sufficient time. This sufficient time, what is it? How do you define sufficient? Sufficient will vary from case to case. Maybe the complexity of the matter. How long can you give this entity time to give you information or information for people to study? How long does it take? So it's a case-by-case situation. And so what happens as you have this process going on, people looking at this information, what do? The key word there is stand still. You all stand still. You don't, all creditors are expected to hold on to their positions, not to demand any payment from the debtor or to press the debtor into any adverse situation that it already is, not to enforce your rights. Just stand still. Allow the person to breathe. Allow this debtor to give you the information. Study it as you do, and consider what you can offer for his growth based on the information that you have available for you. The instance, the very nature of us in these situations, a very basic nature is to try and get an advantage in these situations. But what this principle is asking you is just hold your ground. Do not take advantage of other relevant creditors. Hold on to it. Because you see, if you take your own, the idea, if you say, give me more security, give me security so that I can I mean, I don't enforce now, give me a security, but down the road, that could be a preferred charge and it will be voidable. So think, take a moment and think. You want to tell all creditors, hold on, take a moment and think. So then you kind of start cooperating and coordinating, agreeing to what we call a standstill period. You all hold your positions where you are. As the creditor, as the data also avails all the information that everyone needs to consider how to collectively aid this company out of its problems and so that you can ensure your value is secured. The second principle is this: during the standstill period, all relevant creditors should agree to refrain from taking any steps to enforce their claims against or other than by disposal of the debt to a third party to reduce their exposure to the debt, but are entitled to expect that during the standstill period, their position relative to all others and each other will be prejudiced. I've kind of alluded to this, that you will all refrain, you will all stay put, you freeze, stay where you are. But you're free to sell, to transfer your debt to a third party. That may be useful because the individual, one creditor, may not have the appetite to hang around for whatever reasons there may be. The introduction of a third party who is ready to be patient and participate in a rescue is what this principle allows. And that your positions as relative to each other is not compromised. The way you are expected to stand still and not advance your interest is the same that you will expect of any other who is participating in this process. Yes. Now, principle 3, during the standstill process period, the debtor should not take any action which may adversely affect the prospective return to relevant creditors, either collectively or individually, as compared with the position at the standstill date. So we have been talking largely about the creditors expected to stand still, stay on a standstill, not do anything that prejudices all the other creditors. This third principle is relevant. It makes it an obligation on the part of the debtor not to take any adverse action that will affect the return to any creditor as at the time of the date of commencement. So there is a cutoff date called the commencement date. So if you are being aided in this process, then you are expected to have a certain degree of faith to not prejudice the rest of the creditors that are helping you. The fourth principle: the interests of relevant creditors are best served by coordinating their response to a debtor in a financial difficulty. Such coordination will be facilitated by the selection of one or more representative coordination committees and by the appointment of professional advisors to advise and assist such committees, and where appropriate, the relevant creditors participate in the process as a whole. What this principle introduces now is how the coordination should be done. The key thing is that coordination is necessary. Now, the appointment of coordinators is purposed to facilitate this rescue process, rescue evaluation process. Now, the committees that could be established, the coordinators that may be put in place, could say have what you would call delegated authority if you want to give them. And so they may, depending on the situation, be allowed to appoint lawyers, appoint accountants, valuers, and so on. But of course, this process also helps to get all the information in through one coordinator who then purposely distributes all this information to all the creditors. That way you avoid triangulation by an unscrupulous debtor. Also, it ensures that all creditors get the same information and it's coordinated and given and considered. The creditors involved in this retain their rights to assess this creditor. So it may that they may give this right and obligation to the committee or to a coordinator, but the creditor himself is entitled to assess this information on his own, take independent counsel, and make an informed decision of his own. It helps with time, management of time. So dealing with one coordinating group of individual, rather than run around with different creditors asking for different sorts of information and so on and so forth. So the decisions of these creditors, as they sit in these committees, how do they make the decision, what to ask for and so on? The way this is done really is by consensus. There's no vote. It's a consensual thing. There's not necessarily one having more power than the other. And that helps in de-escalating what is always, as you know, a tricky situation. So that is pretty much how these interests are expected to be managed, that you are coordinated by having either one person or a group of people that are doing these things on the creditor's behalf and are also reporting to the creditors, so that the creditors are at all time in the know of what the other knows. Principle 5, during the standstill period, the debtor should provide and allow relevant creditors and all their professional advisors reasonable and timely access to all relevant information relating to its assets, liabilities, and business prospects in order to enable proper evaluation to be made of its financial position and any proposals to be made to relevant creditors. Now, the key thing here is to evaluate the business process. This information has got to be relevant to the business and is needed for purposes of evaluation of the business prospects and the proposals being made. So who determines what is relevant? Well, that is certainly going to be the creditors, isn't it? If you have given a certain proposal as a debtor, surely the creditors are entitled to say, give us this information or that information or that or the other. There are instances you may find a stubborn debtor who says, but why are you asking that? Well, maybe there are instances where some information may be unreasonable. There could be a debate about it. Why are you asking about my grandmother's date of birth? What has it got to do with my business? Well, it just might be that your grandmother left you a healthy inheritance, and we want you to invest it in this. You see? So the key word is this relevant. The information one is relevant and it relates to the assets, liabilities, and business prospects, so that that information is used to evaluate the company's the company's prospects. But remember that also this process is about rescue. It is about giving you a chance. So the cooperation that is expected, the information that is expected in this purpose is mainly for that purpose. So the proposals to be made relevant to creditors must must also come with a reasonable expectation that you will provide the relevant information needed for the creditors to make that assessment. So again, we see this in principle number 6, which I will read. Proposals for resolving the financial difficulties of the debtor, and so far as practical, arrangements between relevant creditors relating to any standstill should reflect applicable law and relative positions of relevant creditors at the standstill commencement date. Keywords there, the proposal for resolving. The purpose is to resolve. So the proposal is to resolve the underlying, by the way, that's another thing I think I need to emphasize, to resolve the underlying challenges of the company or the causes of this difficulty. So in other words, do not deal with something cosmetic. You're not helping. You may get what you want and go, but you're not helping the rest, the company itself in dealing with the underlying cause. You're also not helping in the company in addressing the underlying causes of its difficulty. You're not helping, particularly the unsecured lenders, creditors, supply creditors, who normally suffer. So you will have to force this company to deal with that ghost. If Oga Madam is the problem, she's interfering in this business, please tell Oga, get Oga Madam out. We need to have a professional manager. That's the problem. You get your money instead and just go, Oga Madam will just continue to cause the problem. So that's where this comes from. Now, the key purpose, as we said, of the due diligence, getting all this information, is to resolve that underlying challenge. And therefore, as you do this, reflect on the applicable laws. As you compare, as you think to yourself, I've got this information. Now I'm looking at it. Where do I benefit? Where am I? Is this the best I can get? The best comparison is the relevant law. What you get where the worst case situation, depending on the law that you have. And normally that's the insolvency law. What will you get in the event of an insolvency situation? Because in that case, then the insolvency law kicks in a liquidation. The worst of them kicks in. But there are many other factors that come into play as you make that consideration. Remember, number one, your ranking in the creditors lineup. Where is your ranking? Are there creditors that are ranking higher than you? What is their claim? 2, what is your claim valid? If there are validity issues on your claim, you probably want to see how to get what you can and go, the best of what you can and go. So in other words, avoid the liquidation, because your claim will be challenged. And all the others, you're now in a liquidation situation, you're dealing with all the other lenders, all the other creditors. So there's more people claiming against the small pie. Your share becomes even smaller. So where do you want to make the comparison? Where do you get more? And that's what this proposal 6, this principle 6 is talking about. If you want to make that reflect, it should be reflected that if you're here, you're in this situation, that the company is making this proposal, you want to make a comparison, go ahead and look at what you have. So look at the relevant date and take what you have, the standstill commencement date. Principle 7, information obtained for the purpose of the process concerning the assets, liabilities, and business of the debtor, and any other proposals for resolving these difficulties should be made available to all relevant creditors and should, unless already public available, be treated as confidential. This really is I think, self-explanatory. Again, this principle highlights why you're getting this information for purposes of resolving an issue, underlying issue of the causing the financial difficulty. But that as you have this information, you need to also share it with you have the same information with other creditors. No one should be more advantaged than the other, regardless of what rights you have. And obviously, if it is not in the public domain, to give some sort of credibility and confidence in this process, keep this information confidential to yourself. So what happens then if you're a bank? If you are representing a bank and it's obviously bound by the confidentiality obligations of the banker-customer relation, then what do? You need to put a clause in the standstill agreement that waives that right, that allows the bank to make the disclosures to all relevant creditors. Now, there are also instances where the data may approach you differently, different offers to different categories or different constituencies, secured lenders or a particular person. What do you do with that information? This principle demands that you make that disclosure to the other lenders, whether in confidence or in some sort of way, because that's what gives confidence in this process. Principle 8, if additional funding is provided or even necessary during the standstill period, or under a rescue or any restructuring process, the repayment of such additional funding should, so far as practicable, be accorded priority status as compared to other indebtedness or claims of the relevant company, of the relevant creditors. Again, I think this is self-explanatory. There are instances where obviously a standstill period will not be helpful if the company if the debtor does not have access to funding. If he doesn't have access to that funding, he may close, you will lose. So who takes that risk? Somebody may take up that risk and provide financing. This rule says it's only fair that the repayment of that facility be accorded a super priority. It's only fair. I think it's only fair. And that's what this principle says. So on the whole, it also says these principles are pretty much just providing for a way in which a discussion or a framework can be arrived at to allow for a coordinated approach of reviewing how this company can be assisted to make its turnaround. 2, how it can be funded, how everyone should behave. So in certain cases, if it can still be availed facilities, avail it. If it's still interested in getting its facilities, yes, go ahead. And it looks down upon anyone, any creditor who is taking advantage of a situation. Some may ask for securities, more securities or guarantees or not, so on and so forth. Hang on, it says, come on, come to us with good faith. Let everybody come with good faith here. So this coordination a little more. If you are able to agree, the all lenders agree, how do you then, what kind of framework do you have that provides for what you have agreed? And the result of this is expected to be what is called, or what at least in Uganda we're now beginning to use and called a standstill agreement, where all the parties commit to stand still, not to enforce what the obligations will be, the funding obligations, if they are ready to, they make me and they dam to that, and how they will aid. Will they give technical support? They may. A supplier may continue to supply at maybe discounted prices or at a set price for a particular period, so that he can participate, help in in promoting this turnaround process. You might have things like I've talked about, the confidentiality, so that you have full disclosures. Of course, the data has to sign this so that he doesn't opt out. He too has the obligation to provide all the information he needs. So the creditors may need, the coordination committee. So that is what you will have, a standstill agreement. Now, what if you escalated and it was necessary to go through a formal insolvency process, and assuming, let's say, it's multi-jurisdictional, group companies across several countries. And these things are not very far because, as you can see, Africa is creating its own business giants. I see UBA here. Those are Nigerian banks that have come here, Guarantee and so on. I see Flutterby. I see all these others. Soon, I'm sure some East African company will come and try to make an entry into your market. But what if there's these engagements that have us make some of these difficult decisions? So what practice has revolved and what is something called the protocol. Obviously, if it's a multi-jurisdictional workout, it is likely that we're going to have to work through the ancestral model law, which I'm sure is applicable in Nigeria, as it is in Uganda. The ancestral model law is an upgrade of the principle of committee. Principle of committee, offering court assistance, court-to-court assistance, recognizing court judgments, that principle, common law, basically good manners, raising a hat for, one bench raising a hat for the other, that sort of thing. With the ancestral model law, you just have a situation that allows for assistance of restructuring processes by allowing direct access to your court and using the substantive law you have. So there is no importation of foreign law, just access to your court and allowing to access what your substantive legal procedures are. That is it. So that's what the ancestral model law does. But as you also have seen it, the question is, how do you improve on that coordination as well? That's where this protocol comes in. And this protocol was first used in the case of the Maxwell Communications Corporations. That was a major cross-border insolvency case in 1996. Maxwell Communications had about 400 subsidiaries across Europe and Australia. And the question was, how do we coordinate all these things? So the practitioners involved in all these cases decided to enter into a protocol, some kind of standstill agreement of sorts, that then they took to their respective courts of jurisdiction to approve. And that is how we have now, we introduced now to this principle, well, not principle, practice of signing protocols where you have quite a number of practitioners involved in an insolvency case. And so what does it involve? And sharing information or developing common strategies, communications amongst court and practitioners as well. And this may look so easy until you start thinking of things like time differences, things like language. By the way, in 1996, there was no Zoom. So you see how coordination had to be well thought about then, and probably even more necessary, because if you don't coordinate, you lose value. Everyone does what you want. You go back to the old regime of everyone doing what he thinks he can do. And the law allows that, by the way, but we all know it doesn't work. So that's how this protocol worked. And it's now commonplace. It's been advanced in ways you can't believe. In the recent case of Nortel Corporation, though they entered into something called interim funding and settlement agreement, under which they agreed, the 38 of the debtors in that company agreed to sell intellectual property of this company that was in distress, or rights that they had under a group. And then they started fighting over this money. Where does this money go? Nortel was in 150 countries. It had just as, nearly as many subsidiaries as Maxwell did. So the question was who does what? And here the conflict seemed to be about how to share this money, particularly between the US courts and the Canadian courts. The operations and of these fundings had been so intertwined, it became difficult to really undo. And the arguments on both courts, had somewhat be coordinated. What did the courts do? The parties agreed to joint hearings between the US courts and the American courts, each listening in on the other. And again, this is way back before Zoom. Back then, of course, they used what must have been the state-of-the-art communication and television equipment and stuff like that. So they were able to listen in and listen to all the witnesses, but everyone, each court really relying on its law and pretending not to kind of be influenced by the laws of all the other countries. And at the end of the day, they delivered the judgment on the same day. In Australia, recently, 2019, the Halifax case, they did the same thing, Australia and New Zealand. Halifax was a sort of a securities company. It had some funds. Some of these funds, and it was an Australian company, it had a subsidiary in New Zealand. Some of the monies had gone into New Zealand, and so there was a fight over this. And the liquidation process, it became necessary to hear in the courts to conduct some sort of joint hearing so that they don't give two divergent views on each other. So this is where this sort of coordination is now going. We're now going well beyond the protocols. So is there a day a Nigerian court will have a joint hearing with a Ugandan court? Quite likely, and some of you may be seated in some of these cases. So the Spencon case is one I was involved in. Spencon was a big conglomerate construction company here in East Africa, had also businesses in Zambia, I believe, and Zimbabwe, and it also had an office in Mauritius. It was a holding company in Mauritius, and when it went down, it had its prop challenges here. The creditors in Uganda had decided to enforce. So when it went into administration in Nairobi, that administration was seen with quite some suspicion, because there had been glaring acts of fraud in Uganda. And even though the recognition of the Kenyan administrator was treated with suspicion and probably ought to have been dismissed, or court was ready to dismiss it, the problem is that the head office had a lot of the information the receivers needed. So there had to be some sort of coordination. And in the end, a consent judgment was entered before court that allowed for some kind of joint coordination between the receivers in Uganda and the administrators in Kenya. So you can see this is no-brainer. There was no way we were going to get that much value without talking to each other. So why does this fail? When does it fail? When does coordination fail? When there's distrust, when there's dishonesty, If you're not, the process, the principles as we saw them, expect a lot of good faith. If you can't come to the process with good faith, good hands, then you stain it and everyone starts looking for personal interest. So dishonesty and mistrust is key. Delayed intervention is another, especially for the data. If you are seeing the dark clouds gathering and you do not make the early disclosures to your lenders so that they can see what to do for you, obviously, by the time there is they come in, it's already a crisis and the lenders themselves are in pretty much recovery mode. So your clients who might be in financial trouble, sometimes, at least in Uganda, we just be clean. Why don't you just go and talk to the banks? There are people like you and me, after all. And sometimes it works. Culture, particularly in institutions, commercial banks, for example, are quick to recover, keen to recover. If you're dealing with money lenders, you know how they are. Those are vultures. They have vulture habits. If you have a PE fund and so on, those are probably not too keen to hang around and support a rescue process. Other banks are probably more keen. Culture in some ways also, I'm sure, even as it is here in East Africa, there are communities, I'm sure, in West Africa who are generally more trustworthy. Their culture allows for consensus. Here, some cultures we have don't allow for that. They quickly grab and go. It's everyone for himself and God for us all. If you misdiagnose the underlying problem that's precipitating the crisis in the company, then obviously you're not helping. I talked about this a little earlier. This process, I want to emphasize, should not be seen to be cosmetic. It has to address the underlying problem causing the crisis. So the coordination will fail or the rescue will fail if you are not agreeing on the underlying crisis. Now, if the coordination is not also, it doesn't have an adequate response and contingency plan, then it's likely to fail. So this really means that you must have a coordinating team that is committed to study and work with the lender towards a turnaround. Some of the lenders we know are kind of hands-off and probably have got young people they have put there, and then this doesn't work. And so that's inadequate and response and contingency plan. And supportive legal and regulatory framework. I do not know about Nigeria here. The Ugandan regulatory framework for banks is keen to ensure a quick recovery. So there's little reward for banks and entities that would be exploring a turnaround. So this seems to be a general African problem. I'm almost sure it's the same in Nigeria. So you have that.
We'll discuss that under the Q&A. We're really running out of time.
And that I end. The thank you comes up on the screen.
Oh, great. I found it very difficult to stop you, Kabito, because you've unpacked a lot of things in quite a short time. I'm sure the fact that this is an appetizer, an introductory, program makes it difficult in terms of time, and I'm sure the audience has a lot to digest. It's been quite illuminating. Thank you so much for breaking down something that is quite complicated and technical and involves a lot of skills and background works, and you know, highly skilled, competent practitioners having to implement principles. As they say, laws and principles are always available. The devil is in the details, and you've made a very great presentation out of this, and that will elicit certainly quite a lot of consideration, thoughts, and questions. I do have two questions that were asked here. I think you can certainly deal with them extremely quickly, and I will try to add an extra 10 minutes, and then I will also excuse my colleague Kubi, who has to leave in a couple of minutes, but I would take care of the rest in the next 10-15 minutes. We'll be rounding up. So we do have a first question. A reference book is being asked. Where can this have a reference book to digest a bit more out of what you have given to us? This is from a practitioner we have 36 states in Nigeria. Is in Gombe State. It's just to let you know that you have people from different regions of the Federation that are here. Yeah.
Oh, thank you. I'll quickly answer that. The statements are laid out. The principles are laid out in what is called INSOL International Statement of Principles for Global Approach to Creditor Workouts. If you just Google that, I'm sure you'll be able to see it. INSOL, it's an INSOL publication. It's available on the net. Just look at it, and it has explanatory notes. And it's somewhere in my presentation. I thought I had highlighted it. I'm sorry if I didn't. So
yeah,
these are.
And Kabito, I think it's important to make the point that these are norms and principles and best international practices that have been devised over time. Yes. With you know, the help of practitioners, and through some of these cases also that you've pointed out, people have tried to standardize the principles so that it may cut things across board. And that takes me to one of the questions I wanted you to answer, which is the fact that you know, you've mentioned about what makes the coordination to fail. I want to focus on what will make, you know, the workout to succeed, and therefore I wanted to ask, in terms of the stakeholders involved, you have the debtor, you have the creditors. Who should you have in place that would actually make? And when I mean by who should you have in place, do you deal directly with the debtor, or do you deal with intermediaries? And what are the natures of the intermediaries if we want to make this to work out? What type of persons do we need to have on the table, in the room, if you actually want the workouts to work?
That's a very, very good question, Corey. Let's start with the frame of mind. If you are a litigious lawyer, I wouldn't want you in the room.
Very well.
If you are one who is down to trying to make a point, egoistic, you're not going to make it. This is a deal. This is a business deal. Let's have a business discussion. Let's open our minds. Yes, we all have our strong legal points. We all have we all have points that we can advance. But I think the key thing is how to structure that deal. The strong legal arguments we have are only guiding us to a deal. So it's not a do or die. You go to court, and I'm sure it's the same in Nigeria, please correct me, that if you go to court, you'll spend how much time? How much value? How much time is lost? Is the payment even adequate for you as a lawyer? Some people are just happy to win. We are not playing to win here. We are playing to have a fairness, a deal. So I would want somebody who is thinking business, somebody who is practical, and somebody who has the bigger picture in the room. Now, the intermediary can be many people. What I do in my case, is when I have to deal with a particular debtor, creditor, whatever I have to do, I first of all, it's a power game. Who has the power? Who is he? Who are his friends? How do we see value? How do you identify? Everyone has a stone in the shoe. If you know what I mean, you have something itching you. So how can I deal with the stone in the shoe? And that's why I like what I do. I am forced to be creative. The law is enabling me. I know the boundaries of the law. I know how far I can stretch it. I'm not going to go and argue about it. It doesn't take me very far. I just want to use it to get a deal. So what we need here are new mindsets, and professionals are key. Accountants, lawyers are key. As the courts get bogged down with backlog and the incompetence of judges, because we have common problems. We know that not the best go to the bench. We know that. Across, we speak about it quietly. Sometimes we are bold enough to speak about it loudly. But here we have the power to resolve this on our own. And so we want somebody with a very new frame of mind, one who has control over his clients and has the ability to rein him in if necessary, because we must have a deal. It's not about what is, this ego of this one or two people. It's much more. It is about people losing their jobs. It's your government losing a source of revenue. It's a community losing a source of livelihood, and so on and so forth. You losing a client. If he liquidates, he dies. You good, get your next client. So I want a person with a new frame of mind.
Thank you very much, insightful. So I have another question that is very straightforward, and in the interest of time, we'll have to deal with that one very quickly. Stanley and B says, who determines the ranking of the creditors and how is it done? Bear in mind that he's asking this question because this is multi-creditor workout.
Right. So the ranking of creditors is determined by law, by your insolvency law. So yeah, I don't know whether I have if you look at multi-creditor rights, then I don't know whether I have the time to go through the COMI.
No, I think you have addressed the issue. I will just add, because this is a Nigerian audience, it will be determined by the Companies and Allied Matters Act. So you would have the insolvency office holder, the expenses of insolvency office holder, the secured creditor by way of a fixed charge, the preferential creditors who have claim as employees or the tax authorities, the floating charge holders, and so on. All of these are contained in the Companies and Allied Matters Act. Now, you do have an interesting question that relates to the standstill period. It asks, how do you manage that in a society that has a huge trust deficit? And in that context, how do you manage the fraudulent intent of other parties in an MCW?
That's a very good question. Uganda is not very different. In one particular case we've handled here, rather than have someone appointed as a receiver or that sort of intervention, what we had was we were appointed as restructuring advisors, and were allowed to have a team. So what we did is have the company appoint us as restructuring advisors, and we were able to go in and oversee things. And it's a new thing. We've done this in three cases here, and they've all worked out very well. clearly here, both the lenders had trust issues. They didn't want to do an informal enforcement and so on. So they just asked the debtor to appoint us as restructuring advisors with a clear term of reference, but it meant that we could go look at the books, walk in. Yeah, we have not dispossessed the individual.
I think you are touching back on the point that I made before asking you that question, because and it addresses as well the issue that the question has raised in a situation whereby the whole foundation of a successful informal workout is that issue of trust and confidence in the parties. So typically there is a bankruptcy of that trust and goodwill as between the creditors and the debtor who is insolvent. And so you will certainly not see the same existing stakeholders being the ones that will lead the conversation. And typically you will be having advisors, professionals that have some level of pedigree and caliber, who will not have a litigation mindset, but a commercial deal mindset, like you've mentioned, and that would then be running the conversation and applying negotiation skills to achieve getting the parties getting to a deal, as INSOL and some of these international organizations used to say. You get to the deal. And so I think you've addressed that question very well. I do have a question here, but it's not really for you. I will say it, but it's not really for you. Maybe for the sake of maybe comparative jurisdiction, you may point one or two things very quickly. It says, where there are numerous law firms involved in a liquidation stroke insolvency, what is the ratio for fees? Of course, that is not your topic, but I mean, as a practitioner, do you perhaps want to give him the practice over there?
Yeah, but I think it comes down to what your role has been. What has been your deliverable. The more you are as practitioners getting involved, I think the more you need to be clear. The clearer you need to be on who is doing what, because it comes down to that sort of process.
I think you should even ask, who is your client?
Exactly. Who is your client?
Yeah. So typically, the question he asked is a bit tricky. Obviously, if you answer that question first, then things are clear. Because if you say different law firms, who are they representing? If they are representing different parties, those are your client, and those are those that pay you. Now, if you do have, again, even different law firms for one client, that is still the client that pays you. And then if you do have a situation where you have other professionals that are working with the insolvency practitioner, then that is the client. And then you become, professional becomes an expense for the purpose of that insolvency administration. A last question here is
pointed that, or just a minute, Corey, that on particular that one is that you need to demonstrate value to your client.
Yes.
If you're seated and there's other people are coming in, then you want to understand what you are selling to that client, and that's what you defend. I learned something from, I think, you not too long ago, about not looking at somebody else's soup dish, counting meat in someone else's soup dish. You look at your own dish.
Yes, that's correct. Thank you so much. The last question here on the list is, what are the specific drawbacks regarding cross-border insolvency within African jurisdiction?
From my experience,
again, I apologize. That's not really, but I mean, multi-creditor workout involves cross-border insolvency as well. So
I'm happy to answer nonetheless. For me, my experience, I think number one has been skill. Insolvency is highly specialized subject, and there is a number of people who just think that you can just handle it. It's not like that. You and I, Corey, know how much we have had to read and talk to get even the basic principles right. Some of the things we can't get them right on the first set. So there is that. There is a lack of skill on the part of the courts, on the part of the practitioners. That is the part. Then the other is trust. A lot of trust. You know, this whole idea of managing creditor rights and somehow putting them in a common pool doesn't seem to sit very well with any court. So the idea is to look after your own creditors first, isn't it? So sorry, your own debtors first. And so I've seen that many times in Uganda. And of course, the other is we have our own burdens. A lot of the cases that we've handled in are coming from Europe. So there are certain prejudices that are coming with that. It's for us, therefore, to step up, and those are the drawbacks you have. Yeah.
Thank you so much. Before we leave, I just wanted to make the point that in your presentation, you've stressed the fact that these principles are applied so that the real cause of the challenge would be resolved, as opposed to just an on the surface treatment. And it's important, therefore, that we situate what is the role of what is called diagnostic business review in multi-creditor workout. Much as the information is given to the financiers, the creditors, and all the rest, this is all towards what you mentioned is the proposal, so that, you know, the proposal cannot be founded in the air. It is founded on an analysis on what are the challenges and the solutions to be applied to it. So where exactly does that exercise take place in the steps that you have? Is it at the point of the standstill or after the standstill? Which comes first?
I think it would depend. It depends on, first of all, the urgency. You know, if you, as you know, some interventions needed a quick, quick. And so
there are even some quick fixes immediately.
And already at that point you've committed. So probably as you're doing the standstill, you're already starting off on the diagnostic review. But if you look at the way this is done, obviously, is that the creditors must first, in some sort of way, agree. They must have some sort of way agree, whoever is in, so that you can start on the diagnostic. If you do it before, supposing that the creditors don't agree, you see, the creditor that may have taken the lead would have taken a risk. But obviously, the findings of that process, or the process as it progresses, will be helpful in informing the decisions of the coordinating committee. And just to emphasize, for me as practitioners, is why you need to see yourselves as differently, whether you are a lawyer or any other. As long as you're in the insolvency space, you can't be seeing yourself so much. I mean, we went to law school believing, or at least my age, that the only thing a lawyer does is go to court. And yet here is a lot of money that can be made in just doing diagnostic reviews. I'm just looking at a new business line for lawyers that you may have.
No worries. We will take time. This is introduction, and the faculty on insolvency and restructuring would be having more technical sessions. And of course, we look forward to working with you in the near future as well. But thank you very much at this stage for your time and a very well articulated presentation. Quite some things to digest for our audience. We are 15 minutes exceeding the time, but I think it's a time well spent. Just to thank you and to mention that by tomorrow, same time, 2 p.m., we have moved from the history and principles to the out of court approach and, preventative approach before formal insolvency or restructuring processes. Tomorrow we'll be taking the restructuring formal options that are available within the Nigerian space. And in the future, would also be taking the solvent restructuring options that are available, and as well, we'll also deal with loan restructuring. So that is all for today, and I will yield for Sarah Ajijola for the vote of thanks and the closure.
Hello, good afternoon, everyone. I want to seize this opportunity to thank you, our facilitator for today, Mr. Kobito. We are very grateful to you. We thank you for your resourcefulness. We also appreciate your insight. I want to
You just got muted, Sarah.
Okay, thank you. So I want to appreciate you, the faculty, for your teamwork, for the whole presentation, also for the hard work you had to put in for this section. We return all the thanks to you all, and we thank the NBA, the Nigerian Bar Association, and also the Institute of Continuing Legal Education for this training. And we want to tell all our participants that they should kindly visit the NBA YouTube channel for the recordings of all the trainings, and also the presentations for this particular series will be shared immediately at the end of the series, not at the end of today's training. At the end of the series, we will share the presentation, the slides to your email addresses. Thank you, and have a very blessed weekend. Thank you.
Thank you. Bye, everyone. Kabito, thank you so much. It's always a
Bye.
pleasure.
Thank you. It's been an honor. Cheers. Cheers.